Welcome, everyone, again to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I'm the founder and CEO of SERMA, Rich Lenkov. We're coming to you actually today from beautiful Colorado Springs, Colorado, the site of our second seminar. We're here at the Broadmoor, so it's a beautiful day. We're excited to have our program today dealing with active assailants at sporting events. We're very pleased to have a return guest, Professor Gil Fried from the University of West Florida. Professor Fried is also the interim assistant dean or associate dean at the College of Business for the university. And he is talking today to us about an issue that's very much in the news involving liability for court storming in the wake of several recent incidents. Professor, welcome back to the SERMAPod.
Rich, thank you for having me back.
So you literally wrote a book on venue safety. When we say you wrote a book, you actually wrote a textbook on venue safety. So you are an expert in this field. I know you've written extensively about it. To give our listeners and viewers some background, we've seen some high-profile incidents, as I mentioned, over the last few weeks, one involving probably the most famous college basketball player right now, maybe the most famous female athlete right now, Caitlin Clark from Iowa, where she got blindsided when a fan came on the court to take a picture. Luckily, she didn't get very hurt. And then last week, in Wake Forest upset of Duke men's basketball team, their star player, Filipowski, got also injured. Again, his leg got injured. He wasn't too severely injured, but it raises lots of serious questions about court storming, which is defined as incidents where fans come out from the stands at either football games or basketball games, like in these situations, and overwhelm the court. And in many situations, it poses a great risk and danger to athletes, to other fans, to personnel. Before we get into those incidents, talk to us a little bit about the history of this, because this is not a new phenomenon by any stretch.
This has been going on probably for over 100 and something years, however long college football has been around, so to speak. This has been popular. I don't think it was as popular in basketball until more recently, which would be in the last 40 years or so. But it is a major issue for venues, teams, athletic departments. We do not see this at the professional level, but at the collegiate level. And it's just saying that the colleges at least understand and appreciate that it is a concern. We also see it at the high school level, and that represents even a bigger concern, I think, in a lot of people's minds, because the minds of high schoolers aren't really well formed. They don't understand and appreciate the risks sometimes, and that could also cause problems. And that's why some of the famous cases that are out there, such as the K case, involve high school court stormings or field stormings. So you see it at the college level and at the high school level. And it might seem fun. It is all fun and games until someone gets hurt. And there are many instances of people that have been hurt during celebrations.
Talk to us about that case, the K case, if you don't mind, because that is one of the more high-profile cases involving this problem.
Sure. So I was the expert witness for the school district in that case, and that was a case in 2004. Mr. K was a high school senior, star volleyball player and star basketball player, and he scored what wasn't the game-winning dunk, but it was an emotional dunk close to the very end of the game. And the students stormed down and they were congratulating him. And when they were jumping on him, someone hit him on the shoulder and, not trying to cause him pain, but it ruptured an artery and he ended up he had a stroke. He became partially paralyzed. He lost his opportunity to play volleyball at Stanford. He was offered a scholarship to go to Stanford and play volleyball there. He ended up still going. They honored the scholarship, but he wasn't able to play, of course, because of his medical state at the time. And while I thought it was appropriate to go to trial, the school district didn't want the negative publicity associated with this because it's a young kid who didn't do anything wrong on his own behalf. But I didn't think there was liability because this had been something that had not happened before at the school. There wasn't an opportunity to put up any kind of barriers And in fact, if you would have put up barriers, it would have caused more of a risk of harm to the students. And it's just a freak accident by a student and their conduct rather than being, hey, this is saying that we did something as an institution that enhanced the risk. So, it's a very tough case, and it's a really sad situation for Mr. K, but I didn't think the school district was responsible or liable in that case.
All right, so you referenced an important legal theory that we discuss frequently on the SERMAPod and in SERMA in general, which is notice, right? One of the key questions to any type of lawsuit in this field is notice, and the plaintiff has to prove that the defendant in these cases had notice. Now, in recent times, given how prevalent these court storming situations are, is it really possible for a university or an arena to allege that or to counter that they didn't have notice? And secondly, how important is it when considering the rivalry involved and an upset possibility? For example, Wake Forest, beating Duke, that's obviously ACC rivalry, but also more importantly in that situation was a huge upset. A couple nights ago, we saw Duke, North Carolina State, two rivals who are separated by maybe 8 miles, right? So when considering whether a defendant has notice, how important is it to consider the circumstances surrounding the rivalry and the teams involved and the rankings, for example?
All that comes into play. But venues are normally very well prepared. They have gone through the process of identifying risk. When I used to do the defense work for MetLife Stadium, we have a 3-inch thick binder for each event, which went through everything: road closures and who's going to man the escalators and what are the post orders and all that kind of information. So normally venues are well prepared. They've gone through this process. They understand. They've done tabletop exercises. But it's one thing to be able to plan. Another thing is, can you execute when there's the variable of people that you can't control what they're going to be doing? So you could try to say, all right, let's try to structure it this way that students might be able to storm the field from this direction or enter the court from this area, whatever it might be. That's fine and dandy. But if people don't follow your plan of what you're hoping to accomplish, how do you respond at that point? So I think they are well prepared. They do plan for it, just like we plan for all those situations, such as a potential bomb threat, active shooter situation, drones, all these different issues. We prepare for it, but there's a difference between preparing for it and the unknown variables that might ensue, such as someone who's running onto the court, as in the Caitlin Clark issue, with a camera trying to take a selfie of themselves, and them not paying attention to their surroundings. At a certain point, it's like the criminal liability for third parties on your property. And if you have noticed that there have been past incidences, then you could possibly be liable if you don't take any steps. However, if you've taken the steps and if you've acted in a reasonable, prudent manner and met industry standards, then you're doing the right thing. So we prepare for it. We know what's going to happen, that there's the potential for it. We take into consideration the rivalries. We take into consideration the time of day, if it's weekend, alcohol sales. And there's many, many variables that we take into consideration. And in the case, at least, of the two primary incidents this past season, both of them involved high-profile games. It was Iowa against Ohio State, two of the top teams in the nation for women's basketball, and then Wake Forest beating Duke. Well, that's always going to be a major, kind of news story. And a lot of people say, oh, you should have had a plan. I'm sure they had a plan. The question becomes, even if you deploy all the security you could possibly bring out there, can they stop thousands of people from descending upon the field or the court?
I want to talk about that standard of care in a moment and what kind of planning must go into these games these days. But before I do that, I want to just follow up on Caitlin Clark, because obviously she is the most high-profile college athlete right now, making a lot of money in NILs. How does the fact that these athletes are now getting paid affect the risk assessment. Because if I'm a risk manager for an arena or for a university, and I know Caitlin Clark's coming to town, I have to be more, uh, I have to plan a little more for the possibility of an incident, given the potential damages that a Caitlin Clark would, suffer versus your garden variety player. So the rise in NILs has to have an impact on the risk assessment.
I don't think it has a huge risk assessment impact. And the reason why I say that is that your goal is to make it safe for everyone if possible. And so you don't want to have different standards of care in terms of we're going to provide additional protection for one versus another. With that said, if you know there are credible threats, similar to the Monica Seles stabbing, if you know that there are threats to individuals, that's one thing. But here, this is a celebratory kind of, issue. And we've seen this with Purdue. They've pulled their players when they were at Northwestern, and it was still with some time on the clock. And they sent all the extra people to the locker room because they knew there was going to be a court storming. There already had been 3 court stormings already involving Purdue and their losses this past year. Because they're the top dog. Everyone wants to knock them off, and if they knock them off, especially in the Big Ten, they think this gives us the right to party. And so I think it's a little bit different in the celebratory kind of environment versus if there's an active threat against someone, then of course you have to take additional steps to protect those people. And that could include having guards behind the players' seating area, or, having plainclothes officers sitting next to them pretending to be basketball players, and all sorts of different tactics can be used. But I don't think it's the same kind of thing in this situation where you're going to want to have, just because of NIL, enhanced security just for one person when it's a celebratory kind of thing. If anything, you want to provide protection for coaches, for referees. There could be, especially with people that have been gambling on a game and they lose money, they might want to take it out on a referee. So there's a whole slew of different risks that we have to be prepared for. And it's hard to engage in an effective risk management plan when you have, let's say, 5,000 people that descend onto a court, and it becomes similar to mayhem. Now, most of the time there aren't going to be any issues, but there can be. And that's why you have to take preventive steps to try to plan for it as quickly as possible. And that could be to have police officers surround players and help usher them off the field. Do the same for coaches and referees as well.
So what other steps, speaking of that, should be taken? I know you've testified extensively in litigation surrounding the standard of care. Where has that standard of care fallen short, and what suggestions do you have for universities to improve that going forward?
So when you start taking a look at the standard of care, the primary one is you have to have one trained crowd manager for every 250 people in attendance. That is a rough standard, and it's from the National Fire Protection Association. The National Fire Protection Association has a rough standard of one trained crowd manager for every 250 people in attendance. Now, that can change depending upon the type of event. If it's an opera or something like that, you might only have, one for every 300 people because you don't anticipate a significant, active crowd. But if it's like a rap concert or something else, you might have one for every 200 people or 150 people. Even with that, even if you had one security person, one trained crowd manager for every 50 people, you can't stop those people trying to rush onto a court or a field. So you have to look at preventive measures. And I like to utilize what's called the layering approach. And the layering approach utilizes multiple things, not just one attempt, but multiple things to try to minimize the potential for concerns. That could be warnings on the back of tickets, announcements over the PA system, announcements on video scoreboards, PSAs, public service announcements from key players or coaches saying, hey, don't do this. There could be the police presence. You can have presence of security personnel, ushers, local priests. I mean, there's so many different techniques that some venues use grandmothers as security people, because no matter how drunk you are, you're probably not going to tee off and try to hit a grandmother in the face, kind of thing. Versus if you're drunk, you might try doing that with a security person, especially if it's a peer security person. So you're always trying to figure out what are some of the best approaches to try to utilize and to try to put them into play. I think the one that I would like to see the most to handle this are going to be policies and procedures involving the student code of conduct, and highlighting that if you do go onto a court or a field, that it's a violation of student code of conduct and you can be disciplined, with the discipline including expulsion from the university. If that is undertaken, I think that would change a lot of different perspectives, especially of students, that they know they're going to be punished. And I think it's going to be pretty easy to be able to accomplish that, because most universities already issue student ID cards with the photographs of the students. They have that. They could put that into facial recognition software and be able to pull out exactly who went onto the court, what they did, and their actions, and then to prosecute them. And that could be everything from trespass bars to prevent them from going into the venue ever again, or maybe for a certain period of time, to prosecuting them for criminal issues if they were to assault anyone or if they were engaged in battery. And then the final point is, what if they in fact injure someone? Then that gives the opportunity for the person that was injured to be able to sue the student or whoever it was that rushed onto the court or the field, and to say, look, you've caused me bodily harm. I'm going after you for negligence.
And perhaps, perhaps even a workers' compensation claim. Now that we know that the Dartmouth student athletes voted to unionize this week, and that's probably the beginning of a trend of student athletes being considered employees of the university. But putting that aside for a moment, last question I have for you on the SERMAPod, Professor, is how successful do you think a contributory negligence counter would be? In other words, the university says, listen, athlete, I understand that you were hurt and I understand you're seeking recovery for that. But now that we know that this is happening, you should be aware of that, and that's part of the risk that you're taking when taking the field or taking the court.
I think it's going to be harder to try to pin the contributor negligence on the player or a coach or a referee. I think against the fan, if the fan gets injured, very easy to do that. In fact, I had a case where it was University of Arizona, and they beat Oregon in a nationally televised major game when Oregon was ranked, I think, number 3 in the country at the time. And they stormed the field afterwards, and a student fell, broke their arm, and sued. And while we got it on the defense side, I was representing the state of Arizona. It was a plaintiff's verdict. They attributed 90% of the fault to the plaintiff himself for his injuries. And so basically we got out of it for far less than what was the demand. So we were happy with it, but it went to trial. You have this on a frequent basis where people get injured in post-event celebrations and they sue, and we bring up either assumption of risk, contributory negligence, or comparative negligence, depending upon the jurisdiction. If it's a player that gets injured, I think that's a little bit of a different story, because even though they might have anticipated there could have been a crowd rush, if they were just trying to exit the court or the field, which is what they are instructed to do, and they get blindsided or hit, that's really not contributing to it. I think if they were part of a celebration, let's say that they're part of the winning team, so they're not the losing team trying to get off the court, but they're the winning team, and they're trying to celebrate, just like we had in the World Baseball Classics. You had a pitcher jumping up and down and then blew out his knee. That's assumption of risk, or you contribute to your own negligence. So in that case, if you're celebrating with people and you get injured, tough luck kind of thing. But if you're from the losing team and you're just trying to get off the court, I don't think contributing negligence will apply there.
Professor Gil Fried from the University of West Florida, home of the Argonauts, repeats a guest on the SERMAPod. Please come back and continue to update us on this and other very interesting topics, Professor. Thanks so much.
Oh, my pleasure. Thanks a lot, and everyone stay safe out there.